Welcome back. You're still watching Far Breakfast right here on Citizen TV. We continue looking at the headlines on News Review this morning. Of course, the biggest headline has to do with the detailed judgment as issued by the Supreme Court yesterday with regard to its annulment of the presidential elections held on the 8th of August. I'm here with Senator Kimani Wamatangi Kiambu, MP Kiminini, Chris Omalwa, MP Kimilili, Didmas Barasa, and now joining the panel, Dan Manzo, MP Makueni. Karibu sana, Bwana Manzo. Even during the break, now the discussion, and of course some of the things that not many people are looking at or asking, and I'm sure it features on one of the headlines, I saw it somewhere, is the big question: where was Smokin Wanjala, Justice Smokin Wanjala? And yes, on page 7 of the Standard, 2 judges missed final ruling on NASA election petition. Of course, even while the hearing was going on, Justice Mohammed Ibrahim was taken ill and had to withdraw from the process. That was rather clear. Yesterday, Justice Smokin Wanjala was expected to be part of the bench, but did not show up in court, although we do understand he signed the majority judgment, which was read by the 3 judges who were present. And the explanation was that he had a flight yesterday morning and he had to travel, and that was it. And of course, during the break, of course, that's the main discussion: where exactly was Smokin Wanjala? Should we look at his absence at face value? Could there be more that meets the eye? And a quick question, Senator.
Yes.
Do you think, are you satisfied with the explanation that he just had to take a flight?
Well, I think in my view, in the spirit of good faith, it would have been very good. At such a momentous time, for a better explanation to be given. Maybe there is a good explanation. If it was maybe on medical grounds, he could have traveled to get medical attention and something like that. Or if it is to that magnitude, then definitely it would be understandable, because nobody can forsake. But the explanation offered at the opening by the Chief Justice was too. It was too simple. He just said that too casual. He just said he just traveled, out of the country this morning, and when the whole country was all eyes glued and all ears, to the ground to listen to what each one of all our 6 judges were saying yesterday morning. Having listened to all of us, it would have been good to hear also his part, because he's a Kenyan who's been entrusted with that position, and more so, his reasoning also has been in previous times, especially during the 2013 judgment, appreciated. It would have been good to hear this time, why did he dissent? What was it that he picked? Just like all the other judges did. So I think, in my view,
he did not dissent on the judge. He was part of the majority judge.
Yeah, that's what I'm saying. He did not dissent. He did not dissent, but it would have been good first. You see, even to show and demonstrate, in my view, ownership of that particular judgment. Presence, Fred, presence.
Presence does matter.
Presence matters. So that's what I'm saying. I think if there is a very good explanation, for example, like if it's on medical grounds, then the whole country will just be.
Yes, that is one question that people will still continue asking. Where was Smokin Wanjala then? Which was this engagement that was so important on such a day when the whole country is watching the Supreme Court, and on that particular day,
I think, Fred, Kenyans have a right to information, and in this case there must have been a very good reason why he traveled. But the critical thing to note is that in his judgment he had actually appended his signature. That is to tell in terms of validity. So to me, if Senator Matangi wants to know more about that, I'm sure the Supreme Court is listening. They can give maybe full disclosure. But I do hope that there must have been a good reason why he has traveled. It might be medical or whatever the case. So really, it's not a big deal as such, because he had made his own judgment, and he had already said that he's going as per the majority, and the Chief Justice made it very clear. He gave disclosure that he has already signed. Yes. So if you really want maybe to know specifics, I think the Supreme Court will be in a position to give you. And lastly, Fred, I want to say something in terms of illegalities and
But Chris Omalo, we'll come back to that, because that's a full discussion we'll have. But on this issue of, because I want to dispense with this issue of the missing judges, and the CJ was very clear the last time Justice Mohammed Ibrahim was absent, that he had been taken ill. This time round, the explanation was Justice Smokin Wanjala simply had to catch a flight. Didmas Barasa, are you reading more on this? Do you think there is something that you're not being told?
Yeah, it's good manners and good practice that when you are delivering judgment, you all make yourself available and present. And I don't think if the Supreme Court had that they have to read out the judgment yesterday, so they would had time to plan on when every one of them was available. So I think I would agree with Senator Matangi that I mean, you read mischief. I mean, it's not that when the day of judgment comes, when you are reading out, then you catch a flight in the morning. I mean, to me that is some elements of doubt.
Because yes, if at all it was a medical issue, and that's probably one of the things we would say it's excusable, a medical issue, it would be very easy to explain. Bonadan Manzo, that's what we saw in the case of Justice Mohammed Ibrahim. A medical issue, the CJ explained and everyone was comfortable. But this time around, the explanation that he had to catch a flight, Justice Wanjala, surely that leaves a lot of questions begging.
Yes, I was personally present in court, and I've been in this process long enough as one of the advocates for NASA. And I want to tell you, on the summary judgment which was given a few weeks ago, Justice Smokin Wanjala was personally present at that particular time. What was important this time around is each judge did not give their own judgment other than the two dissenting judges. They would have also chosen to dissent in one judgment, but they dissented each on their own judgment. Now, that would have been an issue if the other four each also was ascending on their own judgment. Then Justice Smokin Wanjala's judgment would not have been read by in substance. But there was only one judgment which he had signed, and I believe its absence was excusable, and I believe for whatever reason it was a good reason, it was a serious matter. There's no need to speculate. The Chief Justice, who is his boss, was fully aware, and they had excused him to go and attend whatever he was attending to. So I don't think we should read much into it. And the judgment exists, and he has appended his signature on it. He agrees with it. He's part of the four.
But it's rather curious that, and this is a clear divide, that those in Jubilee read mischief. Those on the other side are comfortable and say, okay, it's excusable, it's not a big deal, he didn't need to be there. I'm just saying, that's what I'm saying.
Fred, let me explain this, because I don't want us to make necessarily a big deal out of it. But what we are saying is not necessarily because we're in Jubilee or the other. But my point was, Fred, let me explain myself. I said very clearly that maybe if it was reasons like you've said, if it was medical and any other big issue, life-threatening issue, that would be acceptable. It's okay, the Chief Justice would say so, but you can't run away from the fact that Kenyans asking the question. That's the point. That you find people would be saying, we know that those seats on such a big day for all of us, all of them should be occupied by those that listen. And if you looked at what Justice Lenaola did, he took the first few lines, probably introductory or so. He really didn't go into so much detail as the others did, but you see his presence, those lines that he read signify quite a lot, and you see, as I've said, there is no way you can overlook the meaning, the communication of presence itself, or the communication of the absence itself. I mean, it's a reality. It's a reality. You can't run away from it.
The number of times we get to see the Supreme Court sit on any matter, even in a period of 5-10 years, is like twice or thrice. For him to miss such a momentous occasion definitely leaves a lot of questions begging, and it is part of the headlines. That's why we are addressing it. That headline is on page 7 of the Standard. 2 judges miss final ruling on NASA election petition. Smokin Wanjala was said to be out of the country, while Justice Mohammed Ibrahim was hospitalized in the final days of the petition hearing.
Maybe Fred, just a quick write on that. Maybe one question that one would want to ask, and it's what was revolving in my mind some times back. If you look at the constitution of the Supreme Court is 7 judges, and that gives you the always accepted scenario in an organ like that you have an odd number. That means that in most cases, for whatever decision arrived, you would have a majority and a minority. I mean, you can't divide 7 by 2 to arrive at a decision. And then look at the number of judges who listened. to this particular case. There were 6, and the question that most Kenyans would want to hear answered, including myself, was, for example, supposing there was a tie. Because there were 6 judges that listened. Supposing 3 dissented and 3 consented.
One
would want to be asking themselves is precisely what would be.
I'll answer that to him. Initially when we started the case, Justice Ibrahim was there, so we started as 7 judges. So had there been a tie, I am very sure, because he was very well briefed, he would have been briefed and he would have chosen which side to support.
That's hypothetical.
He participated in the beginning and he is fully aware of what was happening with this particular case.
Okay. Let's go back to the issue of illegalities versus irregularities that we handled just before the break, and I'm sure when Dan Manzo, being a lawyer and having represented NASA in this particular petition, could have an explanation. Of course, the panelists just before you came in disagreed on the existence of illegalities. Yet, when the Supreme Court gave the ruling on September 1st, they said there were both irregularities and illegalities. But from the detailed judgment issued yesterday, it appears that it was more about the irregularities, and people are now questioning were there really illegalities, and if so, who is this? Who should be held culpable?
I think, Fred, before he comes in, you need to report accurately. The gentleman from Jubilee disagreed. I never disagreed. I specified clearly on matters of illegality that the illegalities were there. I even specified the sections of the Constitution. I told you about 38, 86, 88, and particularly the Elections Act. It was violated. So report accurately. I never disagreed. I agreed. We had both illegalities and irregularities, and I went further to clarify the sections of the law that were violated.
Yes. The only part that you are unable to do, because it's done Manzo's time, the only part that you are not able to do, and hopefully he can help you then, is on pointing on which specifics are these that you, because what you're doing is just touching on a broad line of constitutional articles. But it is the election act specific. The election act. When you allege illegality, you are pointing to matters of a criminal nature. So what you're saying is what are those criminal issues?
Yes, I want to tell you that there is now specifically an Elections Offences Act, which is specific on if you commit a crime in this case, which is election in nature. And for you, the Supreme Court judges could not delve into the details of that particular offense because it has to be handled by the DPP, the Director of Public Prosecution.
Absolutely.
And we had alleged that there are particular persons, offences of that nature can be by negligence. You can have something called criminal negligence, that by your own negligence, you committed a crime which you are aware you are doing, or you knew the results of that particular omission or act. And therefore, that cannot be substantively dealt with by the Supreme Court, because the Supreme Court was not having evidence before itself by the DPP. So it is the regime by the DPP. The question is, what if the DPP does not want to pursue? Then individuals who are aware of these crimes can move private prosecution by first giving notice to the DPP. And the DPP so far has stated publicly that he's willing to move into IBC and investigate any of such crimes, because some of them are very heavy. You remember the country is paying heavily for those crimes and for those mistakes, and so that that particular person pays for it, and so that it is not repeated. Remember, there were fake Form 34As, Bs. There were fake Form 34As that they did not have the security features. That was not properly explained. And if they are fake and they found themselves into the system of IBC, then that has to be explained by whoever is in charge.
And that is an illegality.
And it's an illegality. It's also a crime, because a fake document is amounts into fraud And you know, when you do something fraudulently, then it must be given, you know, the proof. The burden of proof is different from the burden of proof of an election petition.
Explain this to us, because, and I'm reading directly, the Supreme Court said it had found, quote, systemic institutional problems, but no evidence of criminal intent or wrongdoing by the commissioners and secretariat staff.
The criminal intent, you know, there was no evidence before them. For them,
so the judgment was not based on any criminal.
It was not based on the crimes. It was not. They did not go to a regime which was not there. They only dealt, you know,
the irregularities.
They only dealt with what we presented before them.
Fred, I have
which is a petition.
I want to tell Manso something that I think is very important. When you say that this form is fake, it can only meet the descriptions of fake if it's authentic, you know, the owner of that document, which is IEBC. If IEBC confirm that indeed this is a fake document, that is when criminal charges against emanating from that scenario can be preferred. Because when you are prosecuting, you will ask the body that owns this document either to disown it or to say this is our document. So it could be that maybe those who are printing those forms were not keen to ensure that we have uniformity in those features. Unless if you have an original document where you are saying this is how the original document should look like. But coming up and saying that these are fake documents.
Are you saying that is just another
irregularity? Yes, I can explain. You know, an original document, first of all, there are regulations under the Elections Act, and it is described how a ballot paper should look like, and our Form 34 by law. Remember, IBC had procured services from other institutions, from third parties. So the moment the investigations begin and they target particular personnel, you know, in IBC, then that personnel will say, look, this is not my mistake. This was committed by the person we procured. And the moment they do that, they become a witness in that particular case, so that when they go to court, they are able to testify, look, these are instructions we gave, this is how our form should be, so this is what we got. And remember, there was a mixture.
Yes.
Remember, there was a mixture of real forms and fake forms, and they could be spotted. And one of the requirements, and you remember it was an issue in court, one of the requirements was a security feature, so that the original document, once you photocopy it, it will show copy. A fake one, once you photocopy it, it was just blank. So somebody must explain that.
You know, so that we don't belabor this point beyond its value. You know, the issue, the point we're making here is very simple. That at the exit point of the judgment yesterday by the Supreme Court, other than then a new process that may ensue from that judgment now, pursuing the Elections Offences Act, that could go either way. It would be a new trial. You pick up people, you draw that evidence, you take it there, and a trial has got either two outcomes. You can go and take those charges to the individuals, and they could fail or pass. So what you're saying is, at the exit point of the judgment yesterday, the judges were very clear that, as you have read there, on the question of criminal intent on the players in IEBC, they found none. That was the judgment.
Okay. No. Misunderstood.
It's misunderstanding.
Before we move to the next slide.
A new process may ensue.
That is very wrong.
Yes, let me explain. You remember when you present a petition, there are very many other election petitions which have been presented. An election petition has particular pleadings, which has particular requests of orders. So you know the pleadings of an election petition are almost civil in nature. The pleadings of under Election Offences Act are criminal in nature. So that's what we're saying. And you know, when you are a suspect, you can either be acquitted or convicted.
Absolutely.
But what the judges are saying, whether someone will be acquitted or convicted in future, we are already satisfied that the process is flawed and the Constitution has not been followed. And in future, we want you to follow the Constitution.
The question was the type of the illegality.
Can you respect the referee?
Because of time, we need to move to the next headline. We need to move to the next headline.
My friend,
no. There must be order.
The question is, a lot moving forward, and according to the orders given by the Supreme Court for a repeat of the presidential election, a lot of the discussion up until today has been about who did wrong within the IEBC. NASA insists that it will not go into the elections with certain people still working for the IEBC. Yesterday, and according to this judgment, very detailed by the Supreme Court, no one has been mentioned. Not even one, not the chairperson of the commission, not the CEO, no one single person has been mentioned. Now, do you still insist on the push to have certain individuals leave the IEBC before the elections happen? And if so, on what basis? Chris Omalo.
Yeah, thank you very much. Now, before I respond to this, I think, Fred, is important to be aware of the Election Offences Act that was passed in Parliament, where people are supposed to be held responsible on whatever happened. And this has been explained clearly by Honorable Manzo in terms of personal negligence. For instance, there is this element of failure to have all forms bearing security features. We need to know who was the person responsible for this issue. So that person must be held accountable. And in the ruling, it's been made very clear that there are some loopholes which were there in the system. And unless these loopholes have been removed, there's no way NASA is going to go back for the elections. But and these are our demands in our...
Chris, that's a different, different procedure altogether.
These are our demands. These are our demands.
Let's allow Malo to
these are our demands in our demands with IBC, because our team went and sat with IBC and gave reasons, and the Supreme Court was very clear what went wrong. For instance, when it comes to the transmission of voters, you realize the question that was being asked during the voter tallying. What was that was happening on TV? Was it the results? We were told there were the statistics. So seemingly, as the transmission was coming in, instead of airing whatever was coming from the constituency, something different was coming on TV, which was misleading people. So in other words, who was this person that was being responsible for this? Remember, there was a court direction that the servers must be opened. And up to now, this was called contempt of court, because IBC never opened those servers for the people from the NASA side and the people from the Jubilee side to ascertain. And this was made clearly yesterday by Justice Milu. She said that IBC should have opened the servers to discredit those allegations that NASA had put in place.
But
so until those servers have been opened, they've been programmed in a good way, so that we don't continue having that thing.
NASA went ahead and mentioned names, pointed out Ezra Chiloba, CEO, ICT Director James Muhati, Voter Education Director Immaculate Kasait, and Legal Director Praxidis Tororei.
Absolutely. Yes. Let me explain.
We did not get any of that from yesterday's...
You don't have to come out with anything from the Supreme Court. The Supreme Court ruled there was an issue which was wrong in the institution, and we know where the buck stops at. If it's something to do with ICT, obviously, the ICT director is the one responsible for that. For instance, there was this issue of Chairman Chebukati's account. You know, the person was being used to do about 900 transactions without his consent. So obviously, who is responsible for that? It is the ICT director.
Are you basing that on the memo, on the leaked memo from IEBC, or on the judgment?
On the judgment. On the judgment.
He's running away from the issue. You're asking a very specific question. The judgment, as read out yesterday, did not specifically mention or indict any specific person, and they have. And you have asked a specific question: are they going to still pursue that line? And Fred, the answer is as clear as they said yesterday after the judgment. The judges were saying something different. They went to announce something different. They said outside the courtroom that indeed that there will be no elections, and the first thing to inform them when one of their colleagues who is a lawyer is here, Mheshimiwa Manzo, is that it is contempt of court, because the court has already given an order that carry out elections within 60 days. So saying there will be no election first is contempt of court. Two, what they are pursuing now is an agenda that they must fast track, because they want these days to close very fast so that they can find themselves in that place they've been calling Canaan in quotes. No. Canaan for them is
a chaotic country that is in paralysis because we have a constitutional crisis as imagined that there would be by them. And that's why you find they have insisted that they are going to continue to insist that those people should leave IEBC in spite of them not being mentioned. But let me finish. Let me finish. You see, let me finish.
Stop it there. Let's just
my point is,
we'll talk about this headline on page 2. Time now for a break.